the president has gazetted the judges who were nominated from magistrates and advocates. There were in total 37 judges from the High Court to the High Court and also to the Environment and Land Court. They were gazetted. You can see the gazette notice. They have been gazetted. We wish them all the best as they are being sworn in so that they become judges. Under the law, after JSC nominates, the president must gazette. After the gazettement in the Kenya Gazette, that is when the president can swear them in at State House in the presence of the registrar of the judiciary and in the presence of the Chief Justice Martha Koome. If she will not be there, her deputy, Justice CJ Justice Mwilu, will be present, but they must be sworn in the presence. They'll take an oath in the presence of the head of state, that is the commander-in-chief of the armed forces. Out of this, we have gone to the archives and found out that why have they been gazetted very fast? Is the president running away from the curse that hit his predecessor, President Uhuru Kenyatta? Are you aware there was a time judges were nominated by the Chief Justice, by the JC? The president refused to nominate them. The president refused to gazette them. The president refused to swear them in for 3 years. What happens? Of great interest, before we go to that matter, there was the issue of Justice Wasame. Justice Wasame was representing the Court of Appeal at the Judicial Service Commission. His term ended. Under the JSC Act, a commissioner serves for a term. It is renewable for another term. Justice Wasame was re-elected. The president refused to appoint him. The president refused to gazette him. The matter went to court, and the court pronounced that whether the president gazettes and appoints if he does not comply with that order of the court, by operation of the court order, he is presumed to have been sworn in. Justice Wasame served his second term at the Judicial Service Commission, courtesy of a court order. This was under President retired Uhuru Kenyatta. So today, President William Ruto has read and listened to the decisions from court, and that is why we bring it to you. Let us look at what happened. This is a matter, a constitutional and human rights petition A311 of 2023. This is a decision of October 8th, 2024 by then Justice Enoch Mwita, judge of the Constitutional Court that time. Today, Justice Mwita sits at the Court of Appeal. The people who went to court are Mr. Justice Agri Mchelule, first petitioner, is a judge of the Court of Appeal. Mr. Justice Weldon Koril, second petitioner, is a judge of the Court of Appeal. Mr. Justice Joel Ngugi, professor, third petitioner, is a judge of the Court of Appeal. Mr. Justice George Odunga, the fourth petitioner, is a judge of the Court of Appeal. Mr. Justice Evans Makori is a judge of the Environment and Land Court of the High Court. And Miss Milady Justice Judy Omanga, she's a judge of the law of the ELC Court in Nairobi. So those are the judges that went to court. What were they going to court? What are the brief facts of this matter? On July 2022, On July 22, 2019, the Judicial Service Commission, JSC, recommended 11 persons, among them the first to fourth petitioner, for appointment as judges of the Court of Appeal. Further, on August 13, 2019, the JSC again recommended 30 persons, among them the fifth and sixth petitioner, as judges of the Environment and Land Court. The JSC forwarded names of those recommended to the former president, herein referred to as the president, for formal appointment as required under Article 166, sub-Article 1B of the Constitution. The former president is His Excellency President retired Uhuru Kenyatta. The president did not appoint the persons recommended and did not give written reasons for not doing so. The president later appointed 7 of the 11 recommended as judges of the Court of Appeal, leaving out the first to the fourth petitioners. Similarly, those recommended for the appointment to the ELC were appointed except the fifth and the sixth petitioners. The petitioner's appointment was only gazetted on September 13, 2022 under President Uhuru Kenyatta and was sworn in on August 14, 2022 after 3 years wait. The petitioners filed the instant petition challenging that delay in appointment as having an endangered violation of their rights and fundamental freedoms. They also sought for orders of damages. So these judges were not appointed for 3 years. Can you imagine? So they went to court. When they went to court, their argument in paragraphs 8, they said the petitioner asserted that the refusal to appoint them caused them public humiliation because of insinuations from the president and other public officials, taking a cue from the president that they were collectively unfit to hold office of judge of their respective courts. This injured their dignity. They also suffered great humiliation and anxiety, physical and mental anguish, given the uncertainty over their appointments. They argued that several violations were committed against them, namely violation of their right to fair administrative action and dignity, mental and psychological suffering and anguish, damage to reputation, loss of yearly increments in emoluments directly linked to period of service, loss of pecking order in the respective courts, and discriminatory treatment when the president appointed their cohorts and swore them into office on April 4th, 2021, leaving them in predicament. So, in this respect, the first to fourth petitioners averred that they suffered losses as follows. September 2019 to September 2020, they lost 4,188,000. They have tabulated the total amount they lost in this. What did the judge, what did Justice Mwita analyze, and what is the judge's decision over this matter? The judge, Justice Mwita, gave the following orders. Conclusion. Paragraph 116, 15. Having considered the pleadings and arguments by parties, the decisions relied on the Constitution of Kenya and the law, I come to the following conclusions. 1. First, the President, Uhuru Kenyatta, violated the Constitution and the petitioner's rights and fundamental freedoms. The first to fourth petitioners were serving judges. They were recommended for appointment to the Court of Appeal but were not appointed. They were kept waiting for 3 years. The fifth and sixth petitioners were judicial officers and one a registrar of the High Court, respectively. They were recommended for appointment to the ELC Court but were not appointed for 3 years, a violation of their legitimate expectation. The petitioners were humiliated, ridiculed, and held in contempt following unsubstantiated claims and innuendos that they were not fit for appointment, despite rigorous interview processes they had gone through. Number 2. Second, the petitioners were discriminated against and suffered differential treatment in violation of Article 27 of the Constitution when their colleagues were appointed, leaving them without any explanation. This caused the petitioners anxiety, mental and physical anguish. They were considered pariahs in the eyes of reasonable members of the society, which diminished their dignity. Lastly, third, the petitioners' right to fair administrative action was violated contrary to Article 47, as no written reasons were given why they could not be appointed. The petitioners not only lost yearly increment, but also pecking order in their respective courts. Disposal. Based on the above conclusions, I make the following declarations and orders. 1. A declaration is hereby issued that the President violated Article 2, 3, 10, 27, 28, 47, and 166(1) of the Constitution during the period July 2022, July 2019, and August 13, 2019 to September 13, 2022, in failing or refusing to appoint the petitioners as judges of the Court of Appeal and the Environment and Land Court after they had been recommended for appointment by the Judicial Service Commission. 2. A declaration is hereby issued that the state, through the refusal or failure by the President to appoint the petitioners as judges after they were recommended for appointment by the Judicial Service Commission for the period that we have done, and rights guaranteed by Article 47. Third, a declaration is hereby issued that the state, through the actions of the President, casting aspersions without particulars that the reasons why he could not appoint the petitioners was because they were not fit to hold public office, violated the petitioners' right to have their dignity respected and protected in terms of Article 28 of the Constitution. 4. An order for compensation is hereby issued awarding each petitioner general damages of Kenya shillings 15 million against the respondent, the state, for violation of the petitioner's constitutional rights and fundamental freedoms. 5. An order for compensation is hereby issued awarding each petitioner exemplary damages of Kenya shillings 5 million against the respondent for abuse of state power, resulting in the violation of petitioner's constitutional right and fundamental freedoms. 6. The petitioners shall have interest on 4 and 5 above at court rates from the date of this judgment until payment is in full. Costs of the petition was awarded to the petitioners, dated and delivered at Nairobi this day of 8th October 2024. Judge E.C. Mwita, judge then of the High Court, now the judge of the Court of Appeal. Are raising. You mean the President has no power to reject to appoint judges? The Commander-in-Chief, remember the arguments President Uhuru Kenyatta had. The President has NIS reports. The President has intelligence reports. He argued that he is the Commander-in-Chief. He can refuse. You mean a head of state, the Commander-in-Chief? That was the President Uhuru's arguments. What did the judges in the court found? In Warsame matter, the court found out that the President is only a conveyor belt. Any decision from JC of who to appoint, the president has no room to reject. The same decision in the 6 judges, Justice Mwita found out that the president has no power to vary, to change, to cherry pick any of the judges. So that is the position of the law. But the president has the power to reject all of them. The president is not a lame duck. Why the president lost in this matter is that he picked out of 41. He left 4 out. Out of the 11, he left 2 out. So the judges said the president cannot cherry pick and say, I'll pick this one, I'll leave this one. But the courts have said the president can reject. And if he rejects all of them. This brings out the question. It went to court. During the interviews of the Chief Justice, the president was given one name. A bill and a law was made saying the president must be given 3 names to choose one. That was the law. It was challenged. And the court said the president, if the president is allowed to pick, to be sent 3 names to pick one, then the president will have control over the independence of the judiciary. All these decisions are aimed at protecting the independence of the judiciary. That the judiciary is independent of the executive. The executive is headed by the president. The legislature is headed by the speaker, and the judiciary is headed by what they call the Chief Justice. Parliament has Parliamentary Service Commission to recruit parliamentary staff. The president has no role. The president has what they call Public Service Commission that employs the people in the executive. And the judiciary has what they call the Judicial Service Commission. It is the one that interviews and employs judges. It is the one that promotes. It is the one that disciplines. So the president has no role. And that is why all these decisions, the president was found faulty. But the president has power to reject. There are no timelines for the president to gazette. So the president is not powerless. The president can reject, just like when a law comes from parliament, the president can reject the whole law and send it back with a memorandum. Here, the President Uhuru Kenyatta failed to get legal advice from the Attorney General and the Solicitor General that time. What is the import of this? If President Ruto did not gazette the 37 judges, and if he fails to swear them in, because he has already gazetted them, they will go to court and they will be compensated. Number 2, who is going to meet these costs? The decision of the judge should have been that President Uhuru Kenyatta should have made this, because he never gave reasons as to why he never appointed the 6 judges. Lastly, the shocker is me and you, the taxpayer. We are the ones going to pay 20 million shillings plus interest and costs. In total, this is likely to be 50 million shillings per each judge, times 6, That is roughly 300 million shillings. Taxpayers, Kenyans are going to meet to reimburse if the president's decision was good. The sitting president then, his decision has been found to be wrong. Could this money be recovered from President Uhuru's own personal retirement package? I think that could be the way to go, because there is no need to burden citizens, the taxpayers, for the offenses of their sitting heads of state. The impunity we see in the executive, the impunity we see in the presidency, the impunity we see in cabinet ministers, the impunity we see in governors when they make decisions not based in law. It is not them who pay those costs. It is you, it is Cyrus, it is Bramwell, it is Vivian, it is Mary, it is Kinyanjui, it is you, Wanjiku, who will pay the judges this amount of money. Wakili Dan Stanomari, bringing it to you, the law. If the president does not appoint a judge, the courts will punish that president. But it is us to pay the money that the courts award. Keep watching Wakili Dan Stanomari, but we wish the new judges, the one who will go to the Supreme Court, all the best. The 37 judges who will be sworn in, if it is tomorrow, we wish them. May God sustain them as they start their new judges of being judges of the High Court and also one of the Supreme Court. Wakili Dan Stanomari.